say it's 7 o'clock and we can kick off this meeting. Welcome and thank you all for joining us. If you could put in the chat room now where you are calling in from, we always like to know that and keep track of it. Welcome also to our guest speaker, Todd Lochner. Todd has worked with CAPCA for many, many years and with lots of our members. And his first presentation we just learned was in 1999. So thank you for sticking with us and for sharing your expertise. I know I'm looking forward to your presentation tonight, as are the rest of the people who have joined the call. Yvonne will be doing your introduction and will be moderating the Q&A. So anyone who has any questions can put them in the chat room as usual. And please, as we've already said in the warm up to this, mute yourselves so that we can hear Todd loud and clear and learn something tonight. So thank you all. And Yvonne, I'm going to turn it over to you.
All right. Thank you, Vicki. Yeah, I'm so glad looks like we have a really great group joining us tonight, which is wonderful. And then I'll get right here going on our intro. So our speaker tonight, Todd Lochner, graduated cum laude from the Tulane Law School with a maritime law certificate from the Tulane Maritime Law Center and a certificate of advanced study and training in arbitration. You know, I just want to stop right there and say that my grandfather went to Tulane as well, and I grew up in Texas, so I feel like that's a point of closeness there. He is a member of the bars in Maryland, state of Maryland, the United States District Courts for the districts of Maryland and DC, as well as the Fourth Circuit Court of Appeals and the 11th Circuit Court of Appeals. He keeps abreast of changes. He keeps abreast of changes in the maritime law as a member of the Maritime Law Association and by, sorry, my phone is acting up on me. Wow, I am not going to be able to get this back. Darn it. Anyway, our speaker, I've given you an amazing resume so far. So with that, I am going to pass it over to you, Todd, and we're really looking forward to reviewing and learning something new about the legal maritime world.
Oh, thank you very much. And I'll begin by asking the question, how long would you like me to speak?
Yes, we usually do about 45 minutes with 15 minutes for question and answer. That tends to work real well for people.
That's perfect. I don't ever wish to stand between any of you and your cocktail. So I wanted to be very clear about how long you wanted me. And we'll do, as you can see, I'm doing a PowerPoint. And as many of you know, I have a very interactive style typically. And I've learned over the course of the years that we've had to do these via Zoom, that particularly when you have a big room, 200 or so people, there's no chance to have any interaction at a really, other than the chat. I'm hoping that we can have some more of that. At the end, I will have, ample time either left. And if somebody wants to tell me that they need me to have the hook, feel free to do so. As we were speaking about earlier, I've actually been giving presentations to CAPCA since 1999. And something popped up on my Facebook feed that I had given a presentation every single year until at least 2012, 2013, something of that nature. And then we started to skip a few. We had those every other year. We were doing the seminars, the delivery seminars, as many of you may recall. And a third of you, more or less, have had the good fortune, or I've had the good fortune of having gotten a chance to know you better through not just my representation of CAPCA over the years, but as individual clients. So for some of you, this may, you may know these documents that I might discuss very well, and others may not. We'll skip over this. Yes, a lot less gray hair. I'm still cheating by using this photo, everybody. here are the things I'd like to cover tonight, give you a little roadmap. So the first two items are updates, things you may not yet know about that are hot off the presses, more or less. And then in order to cover the Captain CYA, we need to do a little bit of Jones Act review. And you'll excuse me for using too many acronyms here, but I think everybody knows where that one's going on the CYA, which is the whole point, to make sure that you're not getting yourselves in trouble. And that starts with prevention rather than on the back end. And I've said to many of you before, I would rather take a few of your dollars by helping with prevention rather than a lot of your dollars on the back end. And I have had clients, captains sitting in my office crying because they didn't do something that they could have done to save their tush very early on. And it turns into something that is a lot longer, drawn out, multiple year process. So we're going to try to avoid all of that. With no further ado, we're going to jump right into some of the new material that you may not have ever heard about before. Well, and again, you guys know I like to have an internet or an interactive, and it's killing me not to. How many people, just a quick, there's a little button if you can find it. And if you have your video on, feel free to raise your hand. But how many people have ever heard of these NOAA speed zones? Got a lot of head shakings no going on right there. A lot more head shaking no. I don't have any hands even in the air. Whether, oh, go ahead, got a couple. We got a couple of people who are acquainted. I have to tell you that I am surprised to see only maybe 3, if I did that scan quickly enough, and well, 4, since Julianne raised her hand. So we have 4 people who've heard about this thing. What you may not have heard about, I'm sorry, Yvonne, go ahead.
I was just gonna say, are we talking about like the speed restrictions for the right whales along the
Yes.
Atlantic coast?
Yes.
Okay, well then, yes, I have heard of that.
Okay. So it looks like I missed Mindy. So we've got about a third who've heard about this. And here's the part that is going to be really interesting. There's a punchline about the changes to come. So let's jump right in to bring the other 2/3 of the group up to speed on this, and then we'll jump to the punchline for those of you who already know the base information. I'm a big fan of Moby Dick, by the way. You can always drop a man anywhere and he will be led to the water. So here is the base information for you. I hope all of you can see what's going on as my screen, it feels a little high, but hopefully that's only a matter of the presenter's view. What's going on with the speed zones are that there are these feeding areas all up and down the East Coast of the United States. Some of them are actually just periods of time and very defined boundaries, as you can see. Now, this has been going on for a long, long time. This is not a new endeavor. What is new is that as of November of last year, they've begun to enforce this against recreational vessels, where the vast majority of you are doing your work. And specifically, the focus up until now has been on recreational vessels 65 feet or greater. Some of you that qualifies and you do that work. However, we are going to be seeing a lot more of these files, and I just concluded one of them actually, which I will tell you about to the extent I am able to do so. It's very interesting how the government is taking its perspective on this thing. I don't read slides, as you're all well aware, but I do want to point out a couple of things. The 10 knot, it's a 10 knot speed restriction. And then this is super important over on the left-hand side, and we'll come back to this. If you're doing anything over 10 knots, look at the things you have to have in your logbook. See them over here in the lower left corner? Notice you have to sign and date the logbook as well. So when it comes to getting one of these tickets, You will make my life a lot easier and your life a lot easier if you have signed and date a logbook entry as to why you were doing the speed you were doing. Now, that assumes, of course, that you are going to get a hail from the Coast Guard at any point in time, and you may well not. It may be a complete and utter surprise to you to get a $20,000 penalty from the federal government 8-9 months after you've finished a voyage. That's the most likely scenario. But to the extent you may have an idea as to why, you'll always want to be keeping that logbook, and you'll want to put all those items that you can read for yourselves down the lower left corner. Slide 2 takes you a little further down the coast, and these are specifically November 1 through April 30. Notice that it is impossible to cross the line of demarcation from the Chesapeake without hitting one of these things during this time frame. So if you are out and taking people out fishing, you're in the Southern Bay, you've got to go offshore to get to the good grounds. You guys know that when you're fishing, the number one thing you don't want to do is go slowly to where you're trying to get to at 5 o'clock in the morning. It's hammers down. You want to be the first one there. This can be a problem November 1 through April 30th. Particularly at this point, if you have a recreational vessel, which is 65 feet or over, but that will change. Notice, next slide, you'll see a little something called the voluntary dynamic management areas. So at this point in time, yes, you're reading that correctly, both the words voluntary and dynamic. Dynamic is the scary word in that. So if someone sees a right whale, they can pop up a new area that you cannot go over 10 knots in. The only way to find these areas is by being attuned to your notice to mariners. Now, I will highly recommend, for those of you who have not already done it, probably the vast majority of you have, is don't just rely on GCAPCA or otherwise to find out, the notice of mariners that matter to you. You can now go straight to the Coast Guard's website, just put in what you want to receive, and it comes up in your email box. These right whale, well, again, I wish we were standing together because I'd ask you guys, how many have you seen popping up? To those of you who have signed up for the service. And I can tell you that my email box was getting pinged with these things left and right for a period of time. These voluntary management areas. They may not always be voluntary. So I'd like to underscore that. It would surprise me greatly if they remained voluntary. And it is quite probable they are no longer going to be voluntary, but mandatory.
Yeah.
And you can see some of that language
Okay.
making it look like you have no choice in some of those notice to mariners that pop up as it is now. So a smidgen of subterfuge, God forbid that should ever come from the government, it has been going on in that context. I stole a couple of these upcoming slides. Anybody know Joe, by the way? He's local. He lives down on Cove Court. No, I'm not seeing any hands or anything, a lot of shaking heads. So Joe's a great guy, but he definitely loves his whales. He's the guy who locally is the attorney enforcing against you in most of the East Coast. I won't say all of it, but a large portion of it. They only have a handful of these folks. They have somebody down in Florida, they've got Joe, and they've got one or two people up north as well. So I stole some of his slides because there is no better way to hear some of this than straight from the horse's mouth, as it were. In May of this year, in my capacity as the chairman of the Maritime Law Association Recreational Boating Committee, which is one of its standing committees, I asked Joe to come and speak about this topic because of that which is afoot. And it really is nice to see it from the horse's mouth, because this is the person that I have to convince, if you ever receive a $20,000 fine, that you shouldn't be paying that fine. At the moment, greater than 65 feet, it's always been for ships. Ships just pay these things because it's part of doing business. It costs more to pay for the stevedores that are asking for double time, to get the ship loaded or unloaded, any lay time, any demurrage, etc., that may go on based upon contract. It's just cheaper to pay the government 20 grand than it is to abide by the rules if they get busted. There has never been a ship that has fought this. There have been no hearings to date, ever. Everybody pays their bill. Joe's boss, the guy I stole these slides from, is pushing for the fines to be much higher. Because if people are willing to pay them, they're not high enough. There has never been a hearing even. So therefore, in his view, they are not high enough. So I anticipate seeing the $20,000 fine, which is what most people have been getting in the mail, will be increased to make it hurt more. Notice what Joe is looking for here in the safety exception. Conditions that severely impact maneuverability and the deviation is documented in the vessel's logbook. And that first slide I showed you more detail on the rule. You have to sign it, date it, et cetera, et cetera. But the fact that this is what he is looking for, you're in the mind of the person who is enforcing against you. This is his slide. So we have to make sure that we're doing those things in the logbook as required in order to give me something to work with if you come and ask me to deal with your $20,000 fine. Now, why do I put an AIS slide up? How's that relevant to these whales? The whales don't have AIS, but guess what? For those of you who don't know, these are the rules around AIS, and this is how they're getting you for these red whale zones. But wait a minute, AIS is supposed to prevent collisions. And if I'm a fishing boat with a bunch of charterers trying to get to their favorite fishing spot before anybody else does at 5:30 in the morning, maybe I should turn off my AIS. So we have a little bit of a problem here. And for those of you who have worked for the government, I'm going to offend you. Just bear with it, because we all know the government at one point in time has had the left hand and the right hand working in opposite to one another. Here's a scenario where that is so. The Coast Guard, kicks and grumbles a little bit, but can't say as much as they'd like to, because everyone is henceforth 65-foot and larger recreational vessel going to be encouraged to turn off their AIS. And under 65 feet, definitely encouraged, because there's no rule that says you have to have it on right now. So you're basically waving around a red flag at a bull in terms of NOAA when you are under 65 feet with your AIS and going through these zones because you're going to get to your fishing spot, or whatever the case may be. And the easier course of action is obviously to turn off your AIS, which of course doesn't do us much good for the whole point of AIS. Again, I don't read these, but note that 65 feet or more inland, engaged in a commercial service. That's why I keep bringing up that charter boat example. Fishing, there are some fishing charter boats. I've represented a ton of these people. They're 65 foot. And to the extent that they are engaged in any commercial activity in that regard, they are required under that through 33 CFR to have it on. So if you're not so engaged, you're encouraged, if essentially by the way the rules are being used to fine people, to turn it off. Not a good thing. Now, here's the punchline. For those of you who knew all of that, these are the proposed changes right now. So one, you can see they get a whole hell of a lot larger. And I assume you can see that part of it's blocked by my view of all of your faces in the screen. But move your screen if I can't move it around. So if it's blocked on the right, I'd encourage you to do it. They get a whole heck of a lot larger. That is a massive increase if you look at the percentage on that they're proposing. Point number two is the one that should create a lot of pucker factor for all of you. Down to 35 feet. Pretty much what all of you are operating when it comes to anywhere that you might be outside the line of demarcation. Most boats in these zones are all 35 feet or greater. So as a de facto, it's turning into a blanket rule. If this proposal goes through, I will say that the NOAA response to the CFR, the Code of Federal Regulations proposal of rulemaking, they have received the largest number of comments ever in response to this. And here's where I would ask for a show of hands. Did any of you make comments while the comment period was open? And if you did, it'll just pop up on all our screens. Just put your hand up. If you didn't, I believe that comment period is now over and you are, like everyone else, just waiting to see where the hammer shall drop. The next item, though, is note that it's the creation of mandatory dynamic speed zones. So that word voluntary disappears. And if they see a right whale zone, boom. They call USCG, notice to mariners goes out on the email. You could be underway already. It doesn't matter. It goes into effect. Whether you received it or didn't receive it, whether you knew or didn't know, as long as it's a notice to mariners out, you are presumed to know the answer. And this has been a little circumspect. The update line item at the bottom, I am going over looking to my right from Joe's actual presentation, hoping that he put in his own speaker notes about where he was going with that, because he didn't. I can't tell you, other than the blanket statement, what they want to do with deviation. But I can tell you that they have taken the position thus far that a vessel which has been hit by lightning and has no electronics still gets a ticket, 20 grand. It's an aggravating, factor. There are lots of tables that the government has on these things, phase 1, 2, 3, 4, and then you've got several factors underneath. And this is all the stuff we argue about when we get into the weeds. None of which I've included here because we were not getting into the weeds with it, but we'll see what happens. So this is what you should have in the pucker factor. This is part of what I'm here to scare you about, is that this will likely change, and it will change the way that we operate on the entire eastern seaboard, as you can see from those proposed zones and how large they are, that you may only go 10 knots. Okay, so there's number one. I hope that if any of you had any questions, just make a little note. And then the second point is the USCG's new initiative on this. Now, because of this slide and what it may lead to, I will not ask for the raising of hands of how many of you have a vessel that is Delaware registered without being USCG registered. Probably not many of you, but they're out there. Quite a few of them. In fact, not more than an hour and a half ago, I have a new client coming in with this very issue, that he's purchasing a vessel of this ilk, a Delaware company that is only exists in the Delaware registry, not in Coast Guard, not in any foreign registry, nowhere. And I have borrowed this one because a couple of slides from Lars Oakmark, who, as you can see, This is another of the from the horse's mouth. There's no better way to get this than what the enforcement folks are thinking. And so I'm using their own words. So here's what the Coast Guard thinks of this. And again, I'm not going to read it to you, but take a second. Just read it real quick. The import of this is that for a host of reasons, and I can tell you some, war stories on this, but for a host of reasons, for the last 4 to 5 years, the Coast Guard has been finding vessels which are running drugs that are Delaware only registered, that are involved with certain oligarchs, and there is no real flag state that can be easily called upon when these vessels are seized, particularly in foreign waters. Coast Guard looks at this as a national security problem. Not part of this presentation, but Customs looks at it as an opportunity to get more money, and which is what perspective they've been taking on Delaware companies in particular owning Delaware only registered vessels. And for those of you who need the background, this is the background. The differences between the state numbering and the documentation side of things. Now, what's becoming, and again, I'm not going to read it to you, but I would encourage you to, while I'm speaking, just sort of read through these differences. Commander Ockmark really highlighted, underlined and in bold, sort of the Alice's Restaurant thing, bigger than everything else on the back side of the page. Kid, have you ever been arrested? Well, he's highlighted all that for you. Those are the takeaway points if you take away nothing else from this slide. We could go on, and I have gone on about this existentialist concept of state of principal operation in other speeches. In Maryland, in particular, since that's where I'm sitting at the moment overlooking the Severn, the court in 2005, our highest court, which was then the Court of Appeals, now the Supreme Court, because the name changed, said that it's okay for the Department of Natural Resources to lie to the public about what state of principal use is on their website. They just have to internally apply the correct formula. So the government is permitted, blessed by the judiciary's highest court, particularly here in Maryland, to lie to you. And that's okay. Specifically about this topic of state of principal use. I know I've been fighting this myth since 1999. So many people believe that it's where the boat is for 6 months. It has absolutely nothing to do with that. And you have an Excel spreadsheet and you're counting the number of days you're in a single other jurisdiction relative to certain jurisdictions, which may or may not give you a free number of days. And then there's a whole existentialist concept of if it's held for repair, some states require a fiscal amount for time not to count as time inside the state for principal use. Like Maryland, for example, you have to pay two and a half times the fair market value for the slip in terms of the repair in order for that time to not count as time. Some poor guy had to pay his whole tax because he was waiting on a part from Italy and the part was only 50 cents. But he had to wait for 6 months for the part. The part cost him over $12,000 at the time because his time no longer counted. So there's a whole discussion about that, but we're going to leave it live for now. Note that these are the purposes. There is even more fungibility being proposed right now because the Coast Guard has proposed that fungibility between the two systems, because the Coast Guard has proposed that now anyone who wants to register a federal mortgage, which could up until now be only registered in federal as a ship's first preferred ship's mortgage, will soon be able to do it in the individual states, even if not documented. which is going to change the entire marine finance world dramatically. But we're not here to talk about that. What we're here to talk about are these changes. Now, one of the things that I did not include in this slide presentation before we go on to the next bit is I did not include what the Coast Guard is currently doing. All summer, they are meeting with Delaware to try to get a new statute put in place, which will effectively eliminate the ability of any vessel to just be registered Delaware. And once they're successful there, that is to say, if it is eligible for documentation. So that means that vessels greater than 5 net tons are all going to be highly encouraged that they must turn to the federal system. And that is roughly speaking about 26 feet in length. And when I say roughly speaking, it's all based upon ad measurement, which is its own hoodoo voodoo system of there are ad measurers, and that's their whole profession, is to figure out how to measure ships. All of us have been usually in the recreational context dealing with the simplified ad measurement form. But nonetheless, the point being, you're going to see anyone still holding out with that Delaware registry, I don't have to go to the federal government, are going to be forced first there. And then if successful, the Coast Guard will continue to meet with other stakeholder, individual state licensing places, and they're going to go to what's known as NASBLA, which is the National Association of Boating Law Administrators. But right now they're laser focused on changing Delaware. Next up, and I'm watching my time here on the other screen. So in order to make sure we get all of the good stuff that we need, we have to do a little bit more of the background. For those of you who already know this, I'm sorry, I'll breeze through it. I hate reading slides. This is nothing more than the stuff that is so dense that sometimes it's easier to read it than just hear it. First and foremost, the Jones Act was a 1924 act, and it has two aspects when you hear about Jones Act. Something called the cabotage laws, which are those laws which restrict non-US built vessels engaging in the coastwise trade. The other side of it is to allow a seaman to sue for injuries. And that's the side we're going to be talking about primarily today. The side, let me just back up a second, see where it says fisheries and coastwise trade. That's the side of the equation of the Jones Act where that comes from, that language. But we're focusing here on the seaman side and the injury side. First, wards of the Admiralty Court. And there was a wonderful quote from the Farnsworth Contracts Case Law book, first year of law school. And it's talking about something called specific performance, which is not relevant here, other than to say, it says, there are certain presumptive classes of sillies, seamen among them, who need the protection of the court. So they are treated like children. And as such, the maritime law has produced a certain way they are protected. Before the Jones Act arrives, there's maintenance and cure. Maintenance is a daily rate to be paid while the injured seaman is recovering. Cure are his medical bills or her medical bills. Typically, most maintenance rates are set extremely low as part of the collective bargaining agreement on ships, usually about $8 to $12 a day. You can't live on $8 to $12 a day, no matter where you are. And certainly not if you're an injured seaman, which is where you will find a lot of people in Key West drinking. You can't get much to drink for $8 to $12 a day. I will tell you that $40 a day is some of the case law that we've seen when it's not available under a collective bargaining agreement. I have recently successfully negotiated, at least through the end of this calendar year, $60 a day for an injured seaman, but it's still not a lot of money. However, if you're the one who's being asked to pay that money, $60 a day becomes a lot of money very quickly for the entire time that the semen is recovering, which can be faster or slower depending upon how satisfied they are with that $60 a day. It's a little callous. That's my defense attorney bent coming out there. I get that. I have plenty of plaintiff's cases, like the guy that I just $60 a day. That was me negotiating for him. So I'm on the plaintiff side too, if the case is right. But my philosophical bent is always on the defense side, where I just successfully solved one with a Puerto Rican seaman. There's quite a cottage industry developing down there, by the way. Tony, I think, might be on board today. Maybe he could even speak to that better than I could. But there are quite a few seamen and some law firms that are suspects. So to the extent you guys are doing any ops in Puerto Rico, be wary. I've seen it, and it is ugly, the kinds of claims that are being brought. Quite apart from the Jones Act, though, maintenance and cure is a classic seaman's claim for the Jones Act. And then there's seaman's wages to worry about as well. Now, the reason I'm bringing this up to all of you is that unless you're the third that I have already engaged with and set in the direction that you should be going, there's a high probability that you're paying whoever's coming along with you to help on a voyage out of a flat rate for the delivery, without any specification that you are not their Jones Act employer. So I would venture to guess that for almost 2/3 of you on the call, given the third of you already being clients, there's a high probability that you are risking being the Jones Act employer every time you do a delivery and you bring someone along to help out. Failure to pay wages, double wage penalty. So if it's agreed in writing with articles, which all of you should have anytime anybody's on the boat and doing something for money, then the penalty for not paying promptly is double. If you don't have articles, one, you're violating a statutory law on that. But two, it is the prevailing wage at whatever port, either that they were brought on or discharged. And so you argue about what is the prevailing wage for a seaman at those respective ports. Clearly, you pick somebody up in New York and you drop them off in BFE, middle of nowhere, near Beaufort or Beaufort, depending on which Carolina you're running into. It's going to be a different answer, because the New York wage is going to be a whole heck of a lot higher than wherever they're being dropped. So there's always an argument there. Make sure you have a written agreement. Moving on now, the last claim that occurs classically in maritime law before the Jones Act is unseaworthiness. Now, we can have a whole discussion, as we have in some other seminars I've given, about what constitutes unseaworthiness and the 3 or so different areas and the different definitions based upon that. We're not going to go there. I'm going to give you the basic one. And I put it out because it's easier to read this one as well, to really retain it. Vessel is reasonably fit for its intended voyage at the time she breaks ground, keeping in mind the vessel could become transitorily unseaworthy. Now, reasonably fit for the intended voyage, everybody knows what a plimsoll mark is, and everybody knows that there are different marks as to the load line based upon whether it's summer, whether it's winter, and where the ship's going to be. A vessel which is perfectly reasonably fit for its intended voyage on the Chesapeake Bay in the summer is not necessarily reasonably fit to be on a voyage in December in the North Atlantic. That's the most evident and obvious way to look at that one. Now, with that said, we then get to the Jones Act. The fight in the Jones Act is 9 times out of 10 status. Are they a Jones Act seaman? So that's the big fight. And we've had a few cases that haven't added too much after Harbor Tug and Barge. So I haven't bothered to sort of muddy the waters more. Harbor Tug and Barge was back in '98, and it's the one that I wrote my case note on when I was in law school in my first published bit. So this is literally lifted from the case note in '98. And you can read it. The gist of it, though, contributing to the function or accomplishment of her mission. And you see how your cousin, who, I'm getting a forced quit applications. I hope that doesn't happen. You can see how the cousin you may have brought along for that trip down from the Chesapeake to Beaufort could be contributing to the mission of the vessel and could meet that test. And furthermore, just because it's not a single vessel, quite a few of you operate on multiple vessels that are owned by a single operator, whether that's Watermark or something else, any of the ones that are in DC. That's all connection to vessels that are in navigation or a group of vessels. So the secondary fight that occurs is substantial both in duration and nature. Now, where this fight occurred in Harbor Tug and Barge is that if you have in this case, it was a painter, but if you have a scenario where the gaming ship is permanently moored with pylons and everything else so that it cannot move, and solid metal plumbing going to the shore, everything else, then you argue about whether or not the waitress who was injured on a slip and fall was a Jones Act seaman or not. For your purposes, almost everybody on board is going to probably be a Jones Act seaman, and which may include volunteers that are not being paid. So for the third of you who have these already, you'll note that's one of the things that I make sure you cover yourself on. With that said, all of that is prelude to what you really wanted. And I'm getting close to my mark. I have until 8, so I'm going to take the prerogative to go a little further and do with whatever we have for questions. With that in mind, 101, how do you protect yourself? First and foremost, many of you are doing this more in the latter years as a retirement business. And so the last thing you want to be doing is to put in all of your hard-earned money, whether in retirement, out of retirement, in a house, for example, that you own outright, all of those things at risk. The easiest way to do this is by doing everything you're doing through a corporate entity and all your contracts through a corporate entity, et cetera. In Maryland, it's roughly a $300 per year that you're paying the government in order to have this extra piece of insurance policy. Please, please, please have the right contracts. I told you guys at the beginning that there was someone who was literally crying on my couch one day. And there were contracts. I was handed the contracts. And I looked at the contracts and I said, I wrote that section, but I didn't write this section and this section. And what the person had done is they had gone to their buddy, one of whom was a client of mine in the past, and taken from their buddy the contract terms that they liked out of those and melded them together with some of the 7 C's contracts and melded them together with some other contracts. And by the end of it, they had nothing that was actually useful. It had all kinds of internal ambiguities and was just a mess. So make sure that you're not doing that. Unless you are a lawyer, please. I don't play surgeon. Please don't cut and paste and think that you're going to be okay. I just lead you back to that poor guy that was crying on my couch. And by the way, you'll note over the last 25 years, after that is when I started putting the little copyright mark on the contracts and giving all my clients a license to use them. Although I like capitalism, and it certainly has a benefit there, it was really as much to protect against having any more people sitting and crying on that couch, because it wasn't the first time that I had seen this happen, where people had taken bits and pieces of the contract packages from former clients and melded them together in such a way with other documents that they effectively meant nothing. So make sure you're delineating delivery versus instruction. There are different beasts at play here. One size does not fit absolutely all. Many of you were doing checkout voyages for individuals that were selling the vessels. And there's a whole nother panoply of whether you are an employee of that brokerage house or not. Some of you were, some of you were not. Some of the houses refused, others wanted you to be independent contractors to them. And then we had to worry about whether or not you were covered and whether if there were mates coming aboard for line handling, who was hiring them, all the stuff we've been talking about. I've been down this path with several different members of the CAPCA organization in various manners. So make sure you're getting the right ones, delivery versus instruction, for example, being the classic one. Those of you who have been down this discussion with me know that we have about 4 different sort of sets we start from and then tailor. And it's delivery versus instruction is one of the prongs that we look at. And then we look at whether we're doing things on your vessel or another person's vessel, etc. And I can't say strongly enough, if you haven't already gotten the point, you never want to be the Jones Act employer. The whole deal is to make sure that the owner of the vessel is the Jones Act employer. It is never you as the captain bringing along someone who needs a little more sea time, someone who, I had a captain who brought a stripper he met along because it was going to be a whole lot of fun from her perspective to go. And he was like, this is great. She wants to have an adventure. No. He became the Jones Act employer of the stripper. That didn't go well. Of course, that voyage originated in Fort Lauderdale and was to end up here and did end up here in Annapolis. To the extent you can do so in a contract, put right in there, owner, you're covering my butt. That's indemnification in the nutshell. Also, you would be shocked how many captains burn through their own credit card. You know, if I'm taking on bunkers, I'm just not going to drop 20 grand on my own credit card. I have seen it time and time again, both defending the owners and trying to get the cash that they're out, real cash, not just their wages, etc., but real cash put out and expended for the vessel. So yes, I play both sides of that fence. It's whoever gets to me with the check first. So I fought that fight and won it both directions. Insurance. You need to be getting yourself and your company added on the certificate of insurance for the vessel, if at all possible. The point is this. The point is to have one adjuster doing the defense have to stand up and talk across the cubicle to the other adjuster who's doing the subrogation, which is to say subrogation is once we have to pay a claim, who can we wring some money out of? And I have had the case literally, because I have been in their offices, I literally, 2 persons who I knew stood up and talked across the cubicle because they were suing one another. One insurance adjuster was suing the other insurance adjuster when there was a certificate of insurance in place, which added one of the parties as the additional assured. Now, fortunately for me, I was brought on for the subro side. So I made my $30,000 for getting 2 adjusters to literally stand up and talk across the cubicle and make it go away so that nobody would ever know and neither would lose their job. I was the beneficiary on that. But that's how powerful it is. It's like, okay, we got to pay the claim, but we can't look for anybody, particularly the captain, to wring the money out, which is one of the primary places when you're on the defense side and then shifted over to subrogation, you're looking for who can we wring the money out of. Checklists, always make sure that you're doing a checklist. and make sure that you're using today's technology to upload it to Dropbox, Box, or any of the other iCloud, etc. Because I have literally had the checklist go down with the vessel off the beach, and the captain waded ashore. This is one of those, I swear to God, this is truth, it's stranger than fiction. I have had that case. Now, in the old days, when I first started giving this talk and I first started doing captain's contracts, I actually had, the carbon, the old style carbon, and I'd get these made up on carbon copies so that as you're going through the vessel, before you get underway, you put one in an envelope and you mail it to yourself. Well, that's my gray hair talking, because we don't need to do that anymore. Now the checklists are largely populated with photographs that are taken, and all of it uploads as a PDF or Word or Excel or however you deem you want to use the checklist to the iCloud or web before you hop on the boat and lose cell signal. So that if you are walking ashore, it's all not on your phone, by the way, because that doesn't do you a lot of good if you're not uploading it somewhere, if everything is lost at sea and you're walking ashore like that poor captain I was referring to. They did recover the engines, but that was about all they recovered from about waist deep after they walked ashore. So multiple contract copies there, and by copies now, I'm talking upload, and checklists. Don't forget to use them. You have to figure out how to make sure that you can identify that that large scrape of 10 feet down the side was not you coming into the piling. It's not hard with today's tech. Now, this is the uh-oh factor of Captain CYA 101. These are just things you need to understand. It is an overview, but limitation of liability. Often a plaintiff's claim can go away in its entirety if a limitation is filed, and it stops all litigation wherever it may be. I have a limitation filed in Cleveland right now, and we've stopped 6 other lawsuits currently pending in Ohio over a triple death and brought them into one place. Very powerful. Now, here's the caveat for captains. It may or may not be available and help you, but you should still know about the concept. Because remember, it's the owner or charterer who can limit, not the captain. And if, in fact, you're able to be on the insurance cover, that's pretty important, because it's the insurance cover that's driving this train. Now, having said that, there are large numbers of marine insurance professionals who have no idea what this is, but you should know what it is. And there's a 6-month date, and that's important. Next up on the uh-oh factor, the Pennsylvania rule. I won't read it to you, but it's a burden shifter. So under the Pennsylvania rule, for example, I litigated a file very early in my career with another Baltimore attorney. And the case was all about whether or not the bunkering barge had appropriately cleaned an area of fuel on the deck, and whether the non-skid that was required by the CFRs were there. Failure to have that would have been a statutory violation, and therefore the burden of proof rested with the bunker owner to show that that violation could have no way contributed to the slip and fall of the seaman. Now, that's not what it's for. It's for collisions, but it has taken on a life of its own, as you can see from that example. Early in my career, I did that one. Another topic, again, I told you we're not going to do this in a big picture because there are lots of reasons that unseaworthiness can exist. But really, you don't get to bring, as a Jones Act seaman, the unseaworthiness claim unless you're a Jones Act seaman. Passengers, those people don't get to bring any of those claims. And the biggest point is, remember that the point of insurance is not to pay claims, it is to deny them and take your premium. The first thing any insurance company is going to do, whether you're on the policy or not, is try to find a way to not pay the claim. That's how they make money. They're not there to be a good neighbor and, keep their hands wrapped around you unless they have to, and only if they have to. Kicking and screaming behind the scenes most of the way. So this is where unseaworthiness is where a lot of carriers can just get rid of their liability altogether, whether you're on the policy or not, leaving everybody hanging out to dry. With no further ado, I am now over time by 11 minutes, leaving a few minutes for questions before I'm in the way of your cocktail hour. Please.
All right, yeah, we do have some questions, actually. Thank you so much. That was, wow, that has brought up a whole lot of questions for me, I know. But here's the first one from a CAPCA member. It says, and actually this may be a question for CAPCA board members as well, is, let's see, do we have, is there a template contract for moving boats available on the to CAPCA members? And the answer to this is yes. But what I wanted to ask you, Todd, is I'm wondering if that came from you, because we do have a contract, several contracts, multiple pages on our website. I don't know, Priscilla, can you speak to that?
Yes, we have some sample contracts, but that doesn't mean they'd be applicable to individual situations. They give you an idea of what kinds of things are in contracts. But it's, it's not a generic thing that you can kind of fill in.
Okay. And and those didn't come, do you know where those came from?
Members kit, they were uploaded to the members kit when we created that particular tab on the website.
Okay, so we don't know if those have been reviewed by Todd or any other lawyer.
Correct, we do not know. You'd have to look and see whether it has somebody's name on it, that they just put what he or she used. We can take a look at that, but there is something that's sort of general guidance.
Okay.
And I would just encourage.
I don't know if you wanted to add. And I noted on your website as well, Todd, that there's a lot of great articles and suggestions there. I don't know if there was anything you wanted to bring our attention to.
Well,
in terms of a
other
template.
than to say the board at various times over the last 25 years has asked if they can post it, the sets. And I have advised against it, not just because of my own economic interest, but it really does require tailoring. And beyond that, it takes at least an hour usually on the back end. And there's a lot of time on the front end as well. For those of you who've been through the process with me, you know this, of talking through the various decisions that you get to make and what the value and what is actually going on in these contracts. Because if you don't understand them, it does you no good. And that's a big part of the reason, not just am I interested in my own loss leader, which those of you have done it and know, I'm just trying to cover as much of my costs as possible because I'm really not making much money in the grand scheme of things.
Okay.
It really just hurts everybody who uses them inappropriately. And I started putting the copyright to discourage uploading so that I would have fewer captains crying on my couch, like the guy I keep talking about.
Okay, all right, yeah, thank you, that's a good point. Okay, the next question is about going back to the right whales and the speed restriction, and it says, when will they vote on the rule for the greater than 35-foot boat rule for speed restriction?
Well, there is no vote. It is an administrative fiat. It is a fiat accompli in so much as the proposed rulemaking has already gone out. Now there'll be a final rulemaking that will happen. And there's no vote, there's no democratic process. It is the, if I could be so brazen, it is those in the NOAA administration who have hugged many a whale who will be making those decisions based upon the input.
I mean, and they're, this is probably not gonna be popular, but they are endangered. There's not too many left, but anyway.
Well, in that context, there are very few that have been ever in a prop strike scenario. and this came about because there were 2 recently, but I think there was something like 6 total ever in recent history that have in the last 20 or so years. So we're not talking lots and lots of these things washing up on beaches because of prop strikes. And therefore, for those of us who have not necessarily drunk the environmentalist bong water on this topic, the cost benefit analysis is what is the big kicker. And that gets even more so when the fine is currently 20 grand. The guy in charge of it wants to make the fine a whole heck of a lot more. And the shut down the East Coast basically for large portions of the year without, so that you may not go more than 10 knots, which increases a lot of costs for a lot of people. And in my humble opinion, puts a lot of business at an economic disadvantage. And, you know, that's why we have politics though, right? But it is those persons now who are appointed in NOAA who will be making those decisions.
Right. I did have kind of a silly question on that one, but if it's sail, I mean, do you have to be mechanically powered? And if you were in a sailboat that went, say, faster under sail and you hit a right whale, would you also be liable for that fine?
Theoretically, if you're over 65 feet, Donnybrook, for example, has hit a whale. I'm not sure it was a right whale. Doesn't really matter under these rules whether you hit a whale or don't hit a whale. Donnybrook has hit one. You guys remember Donnybrook and Jim's boat locally. And they were under sail in a race, had to retire. Don't know what happened to the whale. If that rule had been in effect in their geographic location, they would have theoretically gotten said fine as well. I will tell you that I've been in a scenario in a 505 zipping past the harbor master and the DNR going a whole hell of a lot faster than 6 knots inside the harbor. And I've just been begging for a ticket and while in a sailboat on the wire. But that's a little bit different than what we're describing here because it's not 20 grand. I would have framed that on my wall, but it is theoretically possible that a sailboat could get the fine.
Okay. All right, next question. As a licensed captain on board a friend's vessel for a pleasure outing as a passenger, does my responsibility increase? I think liability is what we're talking about here. Yes.
Correct. And generally speaking, courts are loath to do that. However, on the left coast, California, avocado, alfalfa, sprout land, there is a case, a booze cruise on a J-24, not the captain's boat, just a friend. He was, you know, not even trimming. He was just riding along and some weather came up. He was found liable for not using the knowledge that he had, even though he was not under the color of his license at the time. So it would be a rare circumstance, but it does happen. And there are some cases out of that circuit that show it can happen.
Okay. I think it did. You might have an article on your website about that as well. Is that right? Or I looked at a number of things today. Yeah.
I think so. We try to put as many articles up as possible that spur the questions to keep people out of trouble. And then those who have deeper questions give us a jingle.
Okay. Next question. Someone asked previously, a charter captain, if you have boards, stand-up paddle boards on board and you take out a charter, you anchor, you allow your guests to take these stand-up boards out, they get into trouble. Is there a liability there as the charter company / captain?
To be on impertinence of the vessel and have someone injured?
Yes.
Yes.
So that's an additional liability that needs to be
Quite possibly.
Say a waiver or something like that.
Quite possibly. I'm sure some of you are aware, and I can only speak to what is a matter of public knowledge, but I'm defending a captain who was involved in a death on the Road River in the death of a swimmer in particular. That case has gone in the correct direction. We've won everything at this point, and it is now back up on appeal to the Fourth Circuit, awaiting the decision, because the plaintiff's counsel has basically said that our captain should be on the hook for the death.
Wow. Hmm. Okay, next question. Weed is everywhere, legal in Maryland, not sure about DC, but you could smell it at the waterfront. Are passengers allowed to smoke on board? Could we get into trouble for weed on board?
Yeah, don't take weed on board. In fact, it's still in the charter parties. Thou shalt not light up, period. You will be set ashore and your weed thrown overboard. I mean, no, you're not risking your license. You're not risking the boat. You're not risking all that stuff so that somebody can toke a little bit. There's just no way. It's still federally not available.
Okay. Next question. You had a bullet point on insuring yourself. Did you just, yeah, I guess this person's curious a little bit more about insurance for, I guess, a captain.
Those
in
of you who
addition, I
may
guess, to the
recall the
boats.
approximately 2006, the CAPCA board, myself, and one of my associates at the time, John Sweeney, who you guys may recall, also sat on the board. We all got together and we worked with the MOPS Lancer Insurance, the Marine Operators Policy. That same underlying group, Lancer, we got connected then with some underwriters, and we used MOPS and the London underwriters, and we created essentially for CAPCA, but they were trying to roll it out larger, of course, a policy that allowed you to insure yourself for liability. So back in that 2006 timeframe that came out, almost nobody bought it because the premium was about $3,000, which is now upscale that to today's dollars, and it's a whole lot more. But in 2006, the $3,000 it was too expensive. I am taken to understand that there is someone else who is now currently trying it. I have not had any experience with anyone who has actually filed a claim or gotten that policy, but I understand that there are people out there. People still call MOPS. I'm on the MOPS list, but MOPS insurance is just for the protection of your license vis-a-vis the Coast Guard. So if anyone has a casualty and they're MOPS insured, I'm the guy that gets the call in the middle of the night to come out. There are two of us in the state who get that phone call right now. And I also do DC. I've gone down for some bridge collisions on behalf of captains and things like that. But they're not covering the liability of third parties who are suing.
Okay.
If anybody has any intel about the new one that's come out, the one we put together a decade and a half ago, 15 years ago, did not fly because it was just too expensive.
We have one that's offered in the member section of the website for liability, and it's very reasonably priced, and you can call and talk to somebody directly about what you're looking for and what the coverages are, and they're fairly responsive.
And my question on that, Vicki, is that do we have anybody who's ever actually had a claim?
We just added it last year, so I don't believe so.
Yeah, that's the new one I'm referring to.
It's a fairly 360. I'm trying to think of the name of it. But they are offering that type of insurance that MOPS did, and it's fairly reasonably priced.
Okay, well, if any member happens to have a copy of the policy, I would love to see it, because one of the problems that developed in 2006, and I'm not saying this is so because I have no idea, but one of the problems that was developing in 2006 is as we were negotiating with the London underwriters to try to get this policy for CAPCA members, is that we said, we can't pay $4,000 each. We can't pay $5,000 each. And so they started whittling away at what was actually covered so that their actuaries would allow them to do it. And I have to say that experience and my other experiences in litigation with other policies, often the cheapest policy is the one that has, 15 pages of things that are not covered. And so that gives me some pause if it's super cheap relative to my experience, but I'd love to see it.
I believe there's a sample copy on their website.
Great.
Standard policy, and you
Okay.
can go, and I welcome you to check it out. If you find, that there's a big problem with it, we wouldn't be necessarily recommending it, or not that we're recommending it, but, featuring it on the member site as one of the benefits of discounted liability insurance. They're a AAA company, so it's not a fly-by-night organization by any stretch.
Excellent. Well, if any member should have a claim, I would be interested to hear how that actual rubber hits the road works. With that particular policy.
Okay. We have a member here, Mindy Harbin, who just wants to point out that has worked with you, Todd, and that your firm is very reasonable, has reasonable pricing and personalized service. So, and
Oh,
she's
thank you,
appreciative
Mindy.
of that.
Thank you for the shout out.
And then,
To answer your question in regards to the licensing pack or the insurance that's on the website, I actually called them. And I'm looking, I want to say it's
360 Coverage Pros.
Right. And basically it is insurance for your license. They're working on putting together, I have the lady's name, I just can't find my notes right now. But it covers your license, but it does not offer you any additional liability. If that makes sense, without it being $3,000, $4,000, $5,000, $6,000. So they can't find anybody to underwrite it is what the problem is.
Okay, well, that makes more sense then, because MOPS has always done the license, and they're the ones that have been around for eons. And it was via MOPS that we got the London underwriters to sign off in 2006 and offered the policy. It's just they didn't have enough takers to keep it commercially viable. And that was the very problem we were describing. It was the London underwriters we had to go to and make it fly.
Right. And I think that problem still exists. I know they are working to open conversations about it again. And this was only she told me to contact her back in 6 months. So.
Right. And it takes that kind of time to even have those discussions. It took us 1.5 years of negotiation. I don't know how many of you were on the CAPCA board at the time we were doing all this, but it took us almost 1.5 years of discussions to get to the spot where they were actually offering an underwritten policy that covers the liability third party.
I remember it well.
Oh, I
Hello?
found where I can answer C questions. In the interest of not keeping you guys from your appointed cocktail hour any more so than I already have, as we're 15 over, can I run through some real quick?
of course.
And I don't mean to take away from your moderator responsibilities, but I'm going to do a quick fire so I keep everybody getting their answers and not having cocktails. Boat setter, poorly regulated despite their claims. Do apps like that actually protect us? Okay, first, I represent Boat Setter. I represented their largest competitor, Boatbound, who Boat Setter acquired. They were the guppy that acquired the Goliath. And I still represent them. I have currently successfully litigated this very question in Tampa on a damages scenario. But I successfully litigated it for Boat Setter because Boat Setter is essentially a charter broker. And although they have had some connect the captains stuff going on, they're not an insurance company. by any means. And they're, again, just acting more as a brokerage, and they're not protecting you guys necessarily. Having said that, I drafted the boat-bound charter agreements that formed the basis of what ultimately became boat setters charter agreements. But those charter agreements have absolutely nothing to do with CAPCA. I have not drafted, and I'm not speaking out of school here, but I can tell you that I personally have not drafted any of the documents with respect to the captains that are on the boat setter website. There was another lawyer, Jody, who was involved with that end of things at some point. I'm not sure Jody is still doing that. She's had some family stuff, and I don't think she's quite as involved as she was. But I can reach out and find out, get the Word document sent over to me of whatever they're presenting to you guys. But generally speaking, the concept when I drafted everything for boat setter and boat bound was that particularly there were two classes. It was either a bareboat charter, and then the captain had to get connected with the bareboat charterer, and there was no intervention going on there. There's no contract relationship with boat setter, boat bound. It was just handshaking people. And then the other way that I drafted it is so that someone who is already a commercial operation with their own commercial insurance can post on boat setter, but that's their own problem, and they don't have any of the boat setter insurance. So it was only for the bareboat charters that there's any boat setter insurance, which was originally Concept, and then it became Boat US. Now it's a different company. Concept, the first claim that ever existed in this space, the first thing they did is deny the claim. I sued and litigated for boat bound. I litigated for the vessel owner, and ultimately we got a defense verdict across the board. But the first thing they did was sue boat bound for saying we don't need to cover you. Right about that time is when we negotiated with our friends over in Alexandria and dropped Concept at the time of the casualty. So I hope that's a little helpful. I'm happy to talk to you more about that later without any, client confidences going away. Average legal costs to start a small one-person charter op. So we've already discussed the cost to include full personal protection and the concept of you can't do it on the insurance side yet. Apparently the underwriting isn't there, just like before. With respect to the rest, depending upon where you are going to be incorporating, somewhere between $700 and $1,300, depending upon which state. And that's because there are different fees associated with various states for that portion of it. And then in terms of what the package looks like, depends upon whether you're getting multiple packages. The short of it is, if you get multiple packages, I just cut the second package in half because it usually takes another hour of time to really work through the differences once we've gotten your business preferences ironed out. Therefore, one package, roughly speaking, $800-ish. There's a CAPCA discount that's being given to people. But it's really, when you get the extra package on top of that, then it's, in context, another $400. So all up, depending upon where you are and what you're doing, it could be as little as approximately $1,300-1,400, or as much as $2,000, depending upon what states are requiring what fees if you want to incorporate in those states. See, okay, watermark, hornblower. The answer to the question, do you need your own insurance if you're working for a watermark and hornblower? Most likely you do not need third-party liability cover. You do need the MOPS, or now the 360 apparently is coming in. MOPS being the traditional one that I get the call from, and they pay my bills. And that's just for vis-a-vis the Coast Guard's license action, not for the third party. Because apparently, one, you're probably covered, but two, apparently they haven't figured out the underwriting they tried to do a long time ago. The next question, I don't know if you guys can, I'm sort of skimming these to get through quickly. I think you can all, if you don't have it up, open the meeting chat, you can see the question. That's where I found them. T-boat, full or part-time basis for a corporation where protections, insurance, or legal are usually provided by the employer. One, you have to make sure in that context, this is where I've run into this before, that there's a borrowed servant portion of the marine and a marine rider for vessels that are not necessarily owned by the company, but are being used by the company. Because of the way these things are structured, that's something you're definitely going to want to take a look at. And with respect to just generally, I have a case right now where a captain, after 6, 8, 9, 10 months, couldn't get the vessel to be seaworthy by the company. Failure to actually, and it was a tug as well, and the failure to appropriately report things can get you into trouble. So whether they're your employer or not, just keep that in mind. Next up, limit for an uninspected passenger's vessel is 6 or 12 and will qualify as a bareboat. This is its own discussion for the following reason. NAVIC 6-94 or 7-94. Anyway, the NAVIC came out in 1994. It is still the Bible, but as recently as a couple of months ago, the Coast Guard officers are saying we're having problems and we need to revise the NAVIC of what constitutes a bareboat charter because it is not understood. It is not correct in today's, marketplace on how it's actually working. Having said that, bareboat really is all about surrendering complete command and control. Where this comes to bear for the captain is as follows. If the choice of the captain is the owner's outright, it's not a bareboat, it's a time charter. If there are only 3 names and you only use these 3 people, it won't work and hold the scrutiny. The way we do it is we say, these are the 3 that happen to be approved by our insurance company, and you can bring others if they can get approval. That's the way that you work around it so that the captains who you want to be on the boat are on the boat on a bareboat charter without creating a time charter scenario. And it is incredibly important. We definitively, right out of the box in that piece of litigation, the death on the Road River, that's now in the Fourth Circuit, dealt with this very question right out of the box. Which is another reason, by the way, that you always want to have your maritime attorney on speed dial, because when it goes badly, I literally have gotten in my powerboat, and when it goes badly, you need to control situation and the dialogue as much as you can. And that's not you doing it. It's your representative doing it. And uninspected. So this is the reason this is a 6 or 12 conversation is because if it is a bareboat, then you can have more than 6. If it's a time, you can have only 6. Next up, captain license insurance, how important it is. Well, short of that is that if you're doing everything and getting yourself on as an additional insured, it has a lot less importance than if you do not. We've already determined that apparently the underwriting isn't there. It was years ago. Nobody bought it. So until I hear otherwise, that 360 actually has the third party, it seems to me that nobody has solved that problem yet. So it's kind of a academic question in that context. We talked about 3 coverage pose and my lack of understanding about that. We have a link to it right there. And when I say lack of understanding, I have not read the policy. Employee versus 1099 CYA recommendations. 1, they have to bring their own equipment. There's like a 7-factor list on this thing. They have to set their schedule to the extent that it's reasonable to do so. They have to have their own equipment to the extent it's reasonable to do so. They bring their GPS, they bring their VHF, all the stuff you guys have in your ditch bag when you get on the airplane to go down to Lauderdale to deliver a vessel up here. It's all that same stuff. Your iPad with your Navigating app of choice, stuff like that are the 7 ways that you CYA. And we can talk more about that. I've actually given an entire presentation on this topic to the Yacht Brokers Association, and many of the things there are going to be very similar. But that is its own hours-long discussion. Skipper's choice liability. Now, is that one different than the 360? Because I That's rings a bell to me, the skipper's choice. Who wrote that, Rob?
Yeah, they do liability for delivery captains and things like that out of Lauderdale. They were actually recommended by MOPS at one point when I was looking for this kind of thing. On my licenses, et cetera, some of which are unlimited. They are charging somewhere between about $1,200 to $1,500 a year for up to $2 million of liability insurance.
Okay, so that sounds to me like for the benefit of all of the group as well. If it's possible to get the actual language of the policies in one place and you guys just send them over, I'm more than happy to take a look. If for no other reason, I'd like to be more versed in what other people have been coming up with. I hope that it is good stuff. Skipper's Choice sounds like I've heard that before. The 360 name I had not heard before in the context of third-party liability. But again, I haven't had anybody who's had a claim yet. And hopefully, Rob, you never do, but if anybody has a claim, particularly on the third-party liability side, because I know how these go in the MOPS, and I'd like to see how these newer carriers are responding. Okay, well, I have kept you all from your cocktail a half an hour extra now, so I apologize. If nothing else, I am verbose.
Well, I think it was time well spent. So thank you so much for giving us your time. That was amazing. I think you've opened a lot of eyes and we appreciate it very much.
Well, you're
And
quite welcome. Happy to do it.
yes, thank you. And for your time, I don't know if you can still see me, but we will be sending you a CAPCA mug to thank you for your time and ability to answer all those questions so quickly. And I don't know, we're just gonna have to have you back for all the rest of the questions that pop up over time. And with that, I'm gonna turn you back over to Vicky.
Okay, thank you, Yvonne. Thank you, Todd. Appreciate your presentation. I would just remind the people on the call that we will not be meeting in August. We usually take an August hiatus and we will be resuming again in September. In September, however, our meeting is going to be on the 3rd and not on the 4th Monday of the month, so it will be on September 18th. So if you have your calendars marked for these things, please mark your calendar for the 18th of September for our next meeting. And I hope you all enjoy the rest of your summer. So thank you so much.